Thank you for joining our Government Contracting in Bid Protests webinar, which is in partnership with Manat. My name is James Forrest. I am the Program Coordinator for Norcal PTAC, that is the Northern California Procurement Technical Assistance Center, which is a bit of a mouthful, so we just go by Norcal PTAC for short. And both of our speakers today join us from Manat, Phelps, and Phillips, LLP, which is an integrated national professional services firm bringing together legal services, advocacy, and business strategy with more than 450 professional offices across 450 professionals across 10 offices, including 4 just in California. So a little bit about our presenters here. Randall, who you can see here, he's a partner in the firm's government and regulatory practice. A little bit about him, he successfully defended the highest valued state government contract awarded in in California history, and regularly advises clients on bid preparation, contract negotiations, campaign and bid protests. Randy also advises clients, including nonprofit organizations, on conflicts of interests, ethics, lobbying, campaign contribution requirements, corporate governance matters, grant making, and civic and political activities. So quite the breadth of expertise there. Brandon Young here is also a partner in the firm's government and regulatory practice. And Brandon focuses on public contracting, infrastructure, and public policy. And he represents clients in all phases of public and private procurement, including local, state, and federal government contracts, as well as federal and state bid protests. So Brandon also has experience with commercial contracts involving bridges, tunnels, rail transit, nuclear remediation, information technology, and all kinds of government service providers. So we're very thankful for you two. We also want to give thanks to Olivia Delmage, my counterpart on Manat's end, who is making this possible on the administrative side of things. So thanks, Olivia, as well. And to our audience, I will leave you guys in their capable hands in just a minute. But first, I want to explain a little bit about our services, our program, and what we can do for you. So Norcal PTAC, we are a nonprofit program. We are set up to help small businesses achieve success in the government marketplace. That's what we do. We're funded primarily by the Defense Logistics Agency with extra grant funding from state and local sources. And all of that means that we provide all of our services to the public at no cost to you. We are hosted by the Humboldt State Sponsored Programs Foundation that is located up in Arcata, California. And last year, Norcal PTAC helped our clients win more than $268 million in government contracts. And we're easily on track to break that record for 2019-20 once we get that data all together. So a bit about PTAC. We provide 3 basic core services. The first one, and this is really the meat of what we do, is one-on-one procurement counseling. So we have a team of procurement specialists, and they can meet with you individually to assist with just about any government contracting topic you can think of. So if your business is located in one of these counties that we've highlighted in green here, we can meet with you via phone or video conference and walk you through many of the processes of selling your goods and services to the government. Second thing we offer, regular workshops like this one. These are all virtual these days with the pandemic, and these are all on government contracting topics that we think are going to be useful to you. These are open to anyone to join from anywhere. You don't have to be a client. You don't have to be located in our service area. You can check out our website at norcalptac.org/calendar to find more upcoming events. We'll be hosting more webinars after the holidays are over. Third thing we can do is pretty neat. If you are a client of ours, so if you are located in the service area, you can be set up with a bid matching profile. What this does is it gives you daily access to federal, state, local, and even prime contractor opportunities. So if you have this tool, you'll be notified when a bid request is posted that matches your desired criteria. This helps you stay on top of the opportunities available to you. So as I said, if your business is in one of these counties, you're eligible to apply for our services. All counseling can be provided remotely by phone, email, video conference. You don't need to leave your office. That seems rather important these days. Your home office, that is. So to apply for Norcal PTAC services, you can visit norcalptac.org, click on the red Apply Now button on the page banner, and follow the instructions through step 7. Give me an email if you've ever worked with the SBDC, Small Business Development Center. My email's at the bottom there, info@norcalptac.org. I'll send you a special link to apply. Another note is that we are one part of a large network of independently run PTACs. I think there's about 94 of them across the country. So if you're not in one of these counties, don't stress out. You're probably in the jurisdiction of another PTAC. We all offer basically the same core services. So I encourage you to look up and apply for your local PTAC. A little bit of housekeeping here before we turn things over. You are all muted for the webinar today, but we do have a Q&A that we want you to participate in that's going to take place at the end of the webinar. But we encourage you to enter your questions as the webinar progresses once they come up in your head so you don't forget them. You can do this by clicking on the Q&A button there, and it'll pop up and you can type your question. It'll be submitted even if you don't see it right away. We will get to it and you will see answered questions once we read them aloud and handle them at the end. And in this version of Zoom, we want to be using the Q&A and not the chat. If you have a technical problem or you want to say hi or thanks or something, you can use the chat. But if you want your question read aloud, please enter it in the Q&A function. And this is always important because we always get questions about this, again, is that we will be sharing our slides in the PDF form as well as a YouTube video of this presentation. This is going to be sent out in email and posted to our website later today. So it will all be in your hands. And now I'm going to leave you in the hands of our friends here, Randall and Brandon from Manat. So thank you guys so much and take it away.
Great. Thank you, James, and thank you, Norcal PTAC. Randy and I are thrilled to be with you all today. And we have a pretty cool presentation, in my mind, pretty cool, focusing on California and state local public contracting. And if we can go to the next slide real quickly. Today's discussion is really going to focus on 3 core areas. First, what are the types of contracts that one can expect? The second is, how do I get a contract? And how can I preserve my rights if I don't get the contract that I want? And then finally, once I get the contract, how do I get paid and what happens if the contract ends prematurely? Our spin today will be focused in California. Oftentimes we focus on federal government contracts, just generally, not Randy and I per se, but just as a community. But people forget, California is the 5th largest economy in the world. It is also the 2nd largest source of government contracts given its economy. And it has some of the largest cities in the country: Los Angeles, San Francisco, San Diego. So the opportunities are often less advertised, but they are there. So with that, I'm going to turn it to Randy for the next slide.
Great, thank you, and James, thanks again for this opportunity. This is a discussion about laws that affect public contracting, and as Brandon noted, we're focused on California state and then also local contracts. The sources of legal authority for these contracts come from a variety of sources. For statewide contracts, mostly the Public Contract Code and some of the Government Code also. With respect to local contracts, there can be local rules, local ordinances. There are some provisions in the Public Contract Code that apply. And then different jurisdictions also have their own contract policy manuals that they use. And then lastly, case law, which the courts will adopt rules and laws that apply broadly to all government contracts in California. And then James, the next slide.
So similar to what you would maybe see across the board, the universe of contracts that somebody could potentially bid on runs the gamut. Services, building things, consultancy type contracts. Each of these contracts may have with them, and we'll talk about this a little more today, different types of procurement methods, different types of terms that relate to things like claims and termination. And local and state governments may approach these contracts differently. So for example, in California, if it's a state contract, certain agencies have template contracts that are intended as one size fits all for a lot of terms, and then you kind of narrow that focus depending on what you're trying to do. You'll also see that with larger cities, but it really just runs the gamut. Next slide.
So there are two common types of procurements that you'll see the government issue. And the first one is what people are probably most used to, and that's the low bid situation. And you see this a lot in construction contracts. Typically, the government will issue what's called an invitation for bid. And once bids are submitted, the government has to select the lowest responsible and responsive bidder. They don't have any discretion unless the bid does not promise to do exactly what the invitation for bid asks them to do. The second type of contract that you see more and more of, especially at the state level, is the best value type of contract. And this is a contract that this is a bid that you would see more typically with IP type of solicitations or services type of solicitations, where the government will issue a request for qualifications or a request for proposals, an RFP, and then the government uses its discretion to select the quote unquote best proposal on criteria that they specify in the solicitation documents. So not always lowest bidder. Cost is often a factor in these procurements, but they'll also look at experience, and they'll look at the services that are offered and the solution that is offered and score those. This type of procurement is permitted only if a low bid is not required in the particular situation. And it's usually used for more complicated contracting delivery methods. James, the next slide.
So in any public contracting situation, the threshold question is competitive bidding required? Do I need to go through a process where I submit a proposal or I submit a bid and compete against other companies or firms for the same contract? In California, either from a state or local government, there needs to be a statute that requires competitive bidding for competitive bidding to be required. So what does the law say, and is competitive bidding required? In general, in most situations, you will see that there is competitive bidding required. There are also situations where competitive bidding may be required, and there are exceptions to that. And Randy will talk a little bit about that. And then finally, with respect to competitive bidding, there are situations where, and they are rarer, where competitive bidding is not necessarily required by law, but a city council may ask for their department to solicit bids through a competitive process, which creates a more complicated situation from a legal perspective, because you're not bound by the same statutory requirement per se, but you've gone through a process. And obviously you want to have the hallmarks of kind of a fair and competitive process if that's going to actually happen. So you just need to kind of be aware. If there is no requirement, then there could be opportunities for contracting in what I would call a more atypical or unique situation. Why don't we go to the next slide?
So here we'll talk about some of the common exceptions to competitive bidding. If there is a state statute or an ordinance that requires competitive bidding, some of the exceptions that could apply to that would be the value of the contracts below the dollar threshold. So sometimes you'll see an ordinance that says that any contract over $10,000 has to be competitively bid. And a city decides it needs to let a contract that's only valued at $5,000. They don't have to go out to competitive bidding for that. Emergencies are also an exception. So if an earthquake were to happen, for example, and services were needed right away, competitive bidding would not apply. Public policy exception, where competitive bidding would not benefit the best interests of the state or is impractical or impossible. That often happens in a sole source procurement where there's only one company or entity that can provide the services that the government needs. And the same with unique services or products. And then piggybacking on CMAS or GSA schedules. So cities and local jurisdictions can piggyback on the state's CMAS schedule. And we're not going to get too much into CMAS today, but that's an interesting contracting vehicle that allows the state and some local jurisdictions to purchase things that they would use on a fairly frequent basis off of a contract that's been competitively bid once and then is posted and available for others to purchase off of.
I'm going to just add one thing on this. You know, especially given COVID, you are seeing kind of an increasing number of contracts that are being let on an emergency basis. Whether a government determines there's an emergency really depends on kind of the nature of that government. Something like COVID obviously has prompted local governments to buy things such as face masks without competitive bidding. And you're really looking for something that is an immediate need of the government, that they, you know, the public interest is such that you don't need to go through that process. So I'm mentioning that because you may see it in the newspapers about how just out of nowhere, a large company may have entered into a contract with a city or county, and that's probably the reason why.
Well, and the state just issued contracts this year, huge contracts for the procurement of personal protective equipment, and those were all let without competitive bidding under that emergency exception. Next slide.
So in California, there's this thing called the void contract rule, and it's a creature of case law, which basically says that a contract needs to be made in accordance with the competitive bidding requirements that are on the books. And if you don't follow those competitive bidding requirements, the contract will be deemed void. This is why it's always important to have an understanding whether or not competitive bidding is actually required, and to kind of dot your I's and cross your T's. There are situations, although they are rare, where a contractor will enter into an agreement. That agreement violates competitive bidding rules, and the contract is void. And particularly in situations that don't involve public work, so more traditional services type contracts, governments may even try to disgorge amounts that are paid. Disgorge meaning take back money that was already paid to contractors. So it's something to be aware of, and it goes to the seriousness in at least California with respect to competitive bidding rules and compliance with those rules. The other thing to note is you'll usually see this more where there's a violation plus some sort of bad act being defined as, let's say, a conflict of interest. So maybe a city council member is on both sides, and there are reasons why you would see that, particularly in the disgorgement case. There's a whole different set of laws that would apply. But again, void contract rule, something that's kind of unique to California, but also something to be aware of.
And on that note, you see on the slide that it says that public works contractors may be able to recover their reasonable costs, but no profit if in fact their contract violated the competitive bidding laws. And that's because there were some examples or some cases, 50 or 60 years ago where a contractor was awarded a contract to pave a road, or build some sort of system. And then after they'd done the work, the city refused to pay them because it hadn't been done through competitive bidding. And then the state legislature came in and said, that's not right. So they can at least recover their costs, but just no profit. So our next slide is the bid protest procedures. So a lot of our work is in the bid protest area. And a bid protest is an opportunity for a disgruntled bidder to go to the awarding authority and say, you made a mistake. You should have awarded this contract to me. You should not have awarded it to the contractor that you selected. And And there are no uniform procedures for a bid protest. And in fact, even at the state level, which is the most organized of all the entities here in the state of California, there's no one uniform procedure. The state can choose during its procurement process which bid protest procedure it's going to use. And those are set out in the Public Contract Code and also in agency regulations. The Department of General Services has a plethora of regulations in this area. For local bid protests, you have to go to the city or county or transit authority and see if they've adopted a bid protest procedure. And oftentimes they have not. And then you jump into kind of an ad hoc situation where you're kind of making up a bid protest procedure on the fly. You've informed the city or the county or the other local agency that you're going to file a bid protest. But since you're not following any particular procedures, it can become a mad scramble trying to get all the documents you need and putting together your legal arguments and making your case to the awarding authority. If there is a bid protest procedure, the important thing to remember is that a disgruntled bidder has to file a bid protest if they intend to go to court eventually and seek relief from the court and ask the court to void the contract. If you don't do what's called exhaust your administrative remedies, you lose your right to file that lawsuit. Brandon, do you have anything to add on that slide?
Yeah, just in terms of, thanks, Randy. Just in terms of some practice pointers, if you think that there's going to be an issue, and later in this presentation, we'll talk about some of the common grounds, you need to act quickly. There are timing, most protest procedures have requirements where you need to provide notice of protest or your full statement of protest within 3 or maybe 5 calendar days, sometimes business days. So you need to move quickly. The governments in some cases will take advantage and do kind of a full court press at the beginning by rushing toward a process and kind of a selection decision. So you need to get mobilized and kind of pay attention as much as possible.
Yeah, and I can't tell you how many times Brandon and I have had situations where we've had a client call us and say, we think we want to file a bid protest. And we ask, when was the contract, when was the notice of intent to award released? What are the bid protest procedures? And we find out that a bid protest is due the day after we're having that call, which leaves us pretty, shorthanded. It makes it very difficult to put something in that raises all the issues that need to be raised. So the timeliness is in fact very important. And if you are in a situation where you get a notice of intent to award and you think it's wrong, you should at least reach out to the agency right away, ask them for all the documents that you're entitled to, and then reach out to counsel if you know someone in this area. Next slide.
So what do you do if there are no protest procedures? As Randy mentioned, it's a very ad hoc sort of scenario. And depending on where you are, maybe a local government, maybe a county, perhaps the state, you may need to engage a lobbyist, talk to somebody who has connections with the relevant decision makers. In some circumstances, you can do that. In other circumstances, you can't. Transportation authorities, for example, very often have what are known as blackout restrictions, which basically mean you can't talk to any of the relevant decision makers unless and until the awarding agency actually makes its selection decision. So that might hamstring you. But in other situations where you don't, lobbying can be an effective way to explain why you should have been awarded a contract as opposed to your competitor. Absent that, you are very likely going to find yourself in a legal process. Every disappointed bidder has due process rights. Those due process rights can be exercised either or both locally and in court if there's a protest procedure, or just in court if there is no protest procedure. And in that situation, then you may need to seek legal relief. And I won't bore you with kind of, the difference between injunctive relief and a writ of mandate, but suffice it to say, you get a lawyer to go in court to either halt the execution temporarily of the contract or the performance of the contract, and you get a writ to tell the government to go back and make its decision again, or to issue a new RFP, which is typically the common outcome for things like this. When you are in court, the standards that are going to apply are basically abuse of discretion, which means, did the government do something so unreasonable that it was arbitrary or capricious or inconsistent with proper procedures? Sometimes you can make that case, sometimes you can't. If you're operating in a gray area, it's obviously a more complicated issue. The issues are usually clear depending on the procurement type. So going back to one of the prior slides that Randy mentioned, you have these things called low bid procurements, where usually your abuse of discretion it can be very clear. If you had the lower bid and they selected somebody else, that's a clear abuse of discretion. But in other types of procurements, when something is judged based on best value, that becomes a little more complicated, and we'll get into that. But the judicial process is not a fun one, but it is an important one. Should there be a meritorious basis to dispute the award of a contract? Randy, did you want to mention something?
Yeah, I just want to emphasize again that this slide is focused primarily on local contracts. The state always has a bid protest procedure. They have several different they can choose from, but there's almost always a bid protest procedure available on a state contract. So this slide's really focused more on local jurisdictions, and this lobbying aspect can be very, very important in a situation where you've got a city council that's going to make a decision, or a county board of supervisors. Those bodies really rely on their staff, and if they get a staff report that says that they followed the procedures and this was the contractor that was selected, a city council or a board of supervisors is going to tend to want to go along with the staff recommendation. And so getting to those decision makers before they have the meeting and talking to them and explaining to them the basis of your belief on why the contract should not be awarded that contractor and should be awarded to you is very, very important. If you wait until the meeting itself and get up and speak during your 3 minutes, you're probably not going to have much impact. Also important to energize, if you've got subcontractors or you're working with other contractors on the same contract, to energize, that base. If labor is involved in this, to have labor come out and speak to the decision makers. Can't emphasize enough really how important it is to get to these folks before they vote to approve a contract. Next slide. Brandon, is this me? I lost track.
Yeah, it is.
Okay. So the common protest grounds, reasons why you might want to argue that they should not have awarded the contract to the selected contractor. First off, saying that the bidder is not responsible. And this is a pretty high hurdle to make. You're basically saying that the bidder just can't meet the contract requirements. They don't have the capacity to provide the services, or they've been shown in other circumstances, they've had contracts that have been canceled because they couldn't perform. They're just not able to provide. And that is, it's a high standard to meet, and it's not very common. The more common reason for filing a bid protest is the bidder is not responsive. And responsive means that they did not agree to meet all of the contract requirements. The most common example of this would be a state contract many years ago where the state wanted to purchase brand new copiers, and a bidder submitted a bid for reconditioned copiers that almost met the specifications, but not quite. And the state decided to award the contract, and the courts threw that out because the bidder was not responsive to what the RFP asked for. Other protest grounds, conflicts of interest. We see this every now and then where someone on the contracting team has some relationship, is either employed or was employed, or a spouse is employed or was employed by the awarding authority. And that presents a conflict of interest, and contract should not be awarded because of that. Less common is violation of open meetings laws. So in the local space, that would be the Brown Act. Brown Act violations, we allege those when we can, but they're pretty easy to cure. All of the city council or board of supervisors has to do, if in fact there is a Brown Act violation, is just put the item back on the agenda again and go through the process and re-award the contract. The award of a contract that's substantially different from the contract that was requested in the bid documents. And the example that I gave earlier of the copiers is one example of that. But we see this even on technology contracts where the government will ask for a particular kind of technology, and then at the time that they decide to award the contract, after negotiations, they award a contract that's maybe only half of what the original requirement was. And if they had actually put that contract out to bid, they might have gotten vastly different responses from the contractors. And in fact, we just had a situation like this a few weeks ago. Ambiguous bid specifications are problematic, where it's not clear what the government's asking for. And you get contractors or bidders that submit, very different bids. And the government oftentimes in this situation will choose the cheapest proposal, and the cheapest proposal doesn't offer nearly what other contractors had offered. And then overly restrictive, anti-competitive specifications. We see this a lot, saw this a lot actually with technology years ago, where the government would specify a particular brand and model of technology, and in most situations, the government should not do that. They should just be specifying, what that technology should be doing, and allow the bidders to put together what's the most effective solution for that.
I'll add just a couple of quick notes on this too. There are certain types of protests that can come before you've even submitted your bid. So depending on what your RFP says, or depending on what the local procedures are, there are these things called pre-submission protests or pre-bid protests. Those protests are typically designed to challenge ambiguous bid specifications, or if a specification is overly restrictive. And so you need to just pay attention to that. And then not all bid protests are equal. The remedies for some are going to be different than others. So Randy pointed to a very good example, which is a violation of the applicable open meetings laws, which would be a protest ground that would apply primarily if a local government is making an award decision. Their agendas need to kind of specify what they're going to be voting for, not necessarily who per se, but what. And if there's a contract that's awarded without kind of public notice, then you could challenge that award. But again, all it would take is the city council to come back in its next meeting and simply re-vote on it. But sometimes time matters, and the delay can be used to help if you need to make your case to somebody.
I'll also note that when we're looking at the potential for filing a bid protest, we rely heavily on our clients to help us with issue spotting. Our clients know their world much better than we do, and that they know what the RFP requirements were. They know, what the typical solution would be in that situation. They know enough to go through a competitor's bid and find areas where the competitor provided a solution that didn't meet the RFP requirements. We're not that educated in every area of technology or other services. And so, we always ask our clients to take a very active role It speeds the process up, keeps legal fees down, and helps us to develop the best protests we can put together. James, next slide.
So preparing a bid protest, and I'm gonna just give an overview. I don't know how much detailed discussion is here, but the most important thing besides kind of understanding who's been awarded a contract is why that contract was awarded. So the minute you get a notice of intent to award and you haven't been awarded the contract and you think that you may want to pursue a bid protest, ask for documents. And it can either be informal or formal. Formal is always better because I'm a lawyer, but informal usually is faster and more cooperative. But you want to know, what did the winning bidder propose? What was the correspondence between that bidder and the government agency? How was that bidder scored? What was the agency thinking about when it evaluated its bids? And then kind of what were the background documents that formed the IFB, the invitation for bids, or the RFP, the request for proposals. The cases in California explain that delayed responses to requests for information could constitute evidence of favoritism, so indicative of an unfair process. Usually it's not enough to win a protest on that ground. In fact, I don't think it's ever been enough to win a protest on that ground, but it is enough perhaps to delay an anticipated award decision. And then finally, when it comes to documents, there are distinctions between where you are. The state of California is much more regimented and routinized with respect to the documents that it will provide just as a matter of course. So you'll see, for example, if you have like DGS, which is the largest, it's the Department of General Services, it's the largest procurer of goods in California. When they award a contract, they will also provide proposals. They'll have they'll have their scoring sheets, perhaps a memorandum that explains their decision. Whereas a smaller city may not go through that process, in which case you may need to make a request or do a PRA, Public Records Act request. And then also transportation agencies have certain requirements in terms of allowing a proposal available for inspection. And then finally, certain procurements may allow for what's known as debriefing. And what that is, it's a process where you can sit down with the agency and discuss either what was good or bad about your proposal to help you in kind of a future procurement. Usually those processes occur after an award is made, because governments are smart and they don't want to create a record that hurts them, but that's not always the case. And asking for that might be useful for the future and preserve relationships should you want to pursue contracts with an agency.
And I'll note that we have used that debriefing process when it's been provided before a bid protest was due, to actually help inform the bid protest that we're preparing, and even to delay the award of the contract. And we've been successful in a couple circumstances on having procurements canceled just through that debriefing process. I'll also note that one of the other things that you want to discover during this process is if you were not the selected contractor, where did you land? Were you the number 2? Were you the number 3? Were you the number 4? If there's a formal bid protest requirement, sometimes it will specify that that you have to make a showing that you should have been awarded the contractor, or you should have been awarded the contract. And that's a much more difficult showing to make if you were ranked 4th or 5th instead of 2nd or 3rd. Next slide. So we talked earlier about responsibility, and this is one of the areas that that you can file a bid protest on. And as I noted before, this is not a common grounds for filing a bid protest. Responsibility relates to the quality and fitness, the experience of the bidder to perform the work. If a bidder is not responsible, they probably have a due process remedy, which means that before the contract can be taken back away from them, the government has to have a hearing and allow them to present their case as to why they are responsible. So again, it's just a very difficult protest ground. We don't see it very often. We raise it on a fairly frequent basis in the protests that we file, but it's not an effective tool. Brandon, you want to add anything to that?
The only thing I'll add is if you are contracting with certain local governments or even certain state agencies, they may have something called a pre-qualification process,
Right.
which basically takes a look at who you are as a contractor, tries to determine whether or not you've ever been in trouble for fraud or other sort of nefarious acts as part of a decision on responsibility. And that process may even happen before you submit a bid. And that's one of the reasons why you may not see this as often as an issue, because the government tries to raise and dismiss it pretty early on in the process to avoid a situation where they get too far down the road only to discover that they made a responsibility determination that was incorrect. So why don't we go to the next slide? So bid responsiveness, this is an important slide. It's an important slide because in California, it's probably the largest area for bid protests. And it is also the most fruitful in being able to determine whether or not you have a meritorious ground to protest. So as Randy alluded to earlier when we were looking at bid protest grounds, bids need to conform to what the RFP or the IFB is saying. So going back to that printer example, if the government specified and asked for a printer that prints out 50 pages per minute, and somebody bids 45 pages per minute, and that bid gets selected, that bid wasn't responsive to the RFP. The RFP asked for 50 pages. And why does that matter? Well, it might matter because the difference between bidding at 45 and 50 could affect price. And if a disappointed bidder knew that that could happen, perhaps they would have bid at 45. So it's a very important ground to look at. Now, if there's something more minor and you see this, it's not going to be a stronger argument. And what would a minor variation be? Well, it could be something that doesn't really affect the price, something that doesn't really confer a benefit. To determine whether or not a bid is responsive, and this kind of loops back to the importance of getting information early, you need to look at the proposal of the winning bidder. What did that winning bidder provide, and does it meet the specifications? And if it doesn't meet it, what is the materiality of it? And this is where a PRA request could be useful. This is where if you don't have that proposal, you can argue, well, I'm not getting a fair shake here because I don't know what was proposed. And because I don't know what was proposed, I can't determine whether or not the selection was made fairly and in accordance with the rules and regulations that apply. But you are really looking at what is the face of the winning proposal and did it conform to the specification? Very important, and this is also something where we as lawyers will rely upon the subject matter experts to really help us identify, is there a deviation between the RFP or the IFB and the winning proposal?
I'll note that on this meeting the requirements, something that we see on a fairly frequent basis, both with our clients and with other proposals, is that the government will say, you need to meet these 5 requirements. And the easiest thing to do is to say, I will meet that requirement. I will meet this, B requirement. I will meet the C requirement. And oftentimes, instead of saying that, we'll see in a proposal, a written paragraph or 2 paragraphs explaining how they're going to meet the requirement. And that gives either the government or another bidder the opportunity to say, look, they didn't actually meet the requirement, and this never said they were going to, and what they've said they're going to do does not meet the requirement. And so oftentimes, if you have that situation, our recommendation You know, if it says, can you do X, Y, Z, you say flat out, yes, I will meet that requirement. And then you can provide your explanation if you want to, but just saying you're going to meet that is really all you need to do.
Why don't we go to the next slide? Oh, go ahead. Sorry, Randy. This is you.
I like that big fail. Who put that on there? So common bid irregularities. These are things that we see on a pretty frequent basis in proposals that have been submitted by our clients or by others. The failure to comply with the bid specifications. So, you know, just flat out not, you know, agreeing to comply with something. The failure to sign the bid can be material. If you don't sign your proposal, you can argue you weren't bound to it later. And so, you know, that gives you the opportunity to, you know, walk away from the procurement. That gives you an advantage that other bidders didn't have, because once you submit a proposal, a valid proposal, the government can hold you to it for a period of time, and that's usually specified in the RFP. Submitting a bid late. The government's usually pretty strict about this, and we've had many circumstances where a bid was due by 4:30 and the government locks their doors at 4:30 and a messenger shows up at 4:31 or 4:32 with the proposal. The government won't take it. You have to meet those deadlines. The failure to submit the adequate bid security or a bond, that's pretty straightforward. If they require any sort of bid bond or performance bond, you have to agree to provide that. Irregularities in the submitted price. This happens a lot where you've got several different areas of your bid and each one has to be priced separately and then totaled up, and somehow or other your total doesn't equal what the total actually was. So you somehow your math has gone wrong. Bidders inserting conditions in proposals, and we'll probably circle back to this a little later. This happens a lot. We have clients who ask about doing this a lot. During the RFP process, many times you'll have the opportunity to submit a Q&A process. And if there's conditions that you want to submit into your proposal, that's the opportunity to do it. Ask the government, can I do X, Y, Z? Can you change this particular requirement? An insurance requirement, for example. And if the government says no, then, you know, later on putting that same condition in your proposal is almost a surefire way to get disqualified. The failure to obtain necessary licenses. You see this a lot in construction contracts where a general contractor's license or electrician's license or something of that sort is required, and it turns out that the contractor who submitted the bid actually doesn't have a valid license at the time that the bid was submitted. And then the failure to identify subcontractors if required. Again, we see this most often in public works contracts, construction type contracts, but even on technology contracts, if there's going to be a number of subcontractors and the RFP requires that you list the subcontractors and you don't, you can be disqualified for that. And I will note also that this list is something that we would give to our clients who think that they want to file a bid protest. And we would say, here are the things that you want to consider when you're going through your competitor's proposal. You know, does it look to you like any of these things happen with their proposal? Brandon?
Why don't we go to the next slide? Just some additional protest related issues, and these are more unique and dependent on the type of contract. The first are small business or disadvantaged business bid preferences. Certain contracts will require or will have set asides for small business or disadvantaged businesses. If a company doesn't, or a bidder doesn't satisfy those requirements, perhaps by recommending a company that is not certified as a disadvantaged business enterprise, then that can be a protest ground. You'll see this most commonly in the federal transportation space or state contracts with federal transportation monies. So your Caltrans contracts, for example. Though larger cities also have similar programs, like the city of Los Angeles will have small business or local business or women-owned business bid preferences in some of their contracts. Bid collusion is prohibited. So that would be a situation where two bidders may have colluded about, submitting a bid or aspects of a bid, oftentimes to maybe run up a price. So another bidder's price looks better by comparison. Very rare, also illegal. So try to avoid that. And, obviously if something like that is going on, it would be a basis to void a contract or a bid. Alternative bids. Now this depends on the IFB or the RFP, but an alternative bid would be a bidder saying, you know what, I have option 1 or option 2. If you can either pick option 1 or option 2. Some RFPs allow it, some don't. So you just need to be careful. Bid splitting. Bid splitting occurs when contracts are broken up into smaller amounts to avoid competitive bidding requirements oftentimes, and can't do that. Loss leaders. This is somebody where, or a situation where a bid is so low that there's some, that they're trying to take advantage of a low price just to get the government business. Very hard protest ground. You see it more in the federal context. And I don't believe there's been a case in California that's actually acknowledged a protest based on this ground, but there are statutes on the books that prohibit loss leader contracting. And then finally, bid shopping, which may be of interest to some on the phone, where a prime contractor essentially walks around and discloses its subcontractor bids before the overall bid is due. And that would happen in a situation where a GC is trying to bring down its costs of subcontractors, and that's barred under state law. Next slide.
Next slide. So if you file a bid protest, what do you get out of it? Very rarely will you actually get the contract awarded to you. The most common thing that happens if you successfully file a bid protest is that the government cancels the procurement and starts over. And we always advise our clients about this right at the very beginning of a bid protest discussion, because clients, if we don't do that, if we don't tell you that, then clients get very upset towards the end when it turns out the bid protest was valid. And instead of getting the contract, everything just gets wiped out and you start all over again. As far as damages, if you win a bid protest, there's almost no basis for attorney's fees. So you don't recover your legal costs for filing the protest. In some circumstances, you might get the costs that you incurred for preparing your bid. And this would be, more relevant to bigger contracts where we've seen circumstances where bidders have spent $500,000 or more preparing their proposal. But there's no case law right now, and there's no statute that allows for recovery of lost profits, because those are speculative. Again, the most you can usually get out of a bid protest is the opportunity to bid on that contract again. Brandon, next slide.
So now you have your contract and hopefully things are going well, but there are situations where the government may order extra work, and there could be an entire presentation on this slide alone. But what Randy and I wanted to do is at least expose you to the contractual claims process. And every contract, or I shouldn't say every contract, most contracts have a set process that allows for a contractor to say, wait a minute, the work's changed. This wasn't what I was expecting. I'm entitled to additional compensation, or I'm entitled to more time on my contract. And it can be when there's new work. It can be when there's a problem with the specifications. So the specifications are what's known as being defective. So they've asked you to build something and you find out it's impossible to build based on what was written, or information wasn't disclosed to you. Probably right now, what we're seeing the most in this process is force majeure, right, with COVID. Contracts may include a force majeure provision. There's also California statutes that talk about this. But the lesson for all of this is, if you see something that you think is different or is going to cost more money or is going to take more time and it's not your responsibility, or you don't believe it's your responsibility, give notice to the government, tell them exactly what the situation is, and you can always supplement and provide more information, but let them know, because if you don't, you can find yourself in a situation where you've waived your rights to additional compensation or time.
And James, let's go to the next slide. So we'll note that we could probably do a whole presentation just on claims. So we're gonna hit this real quickly and then move on and take some Q&A. Some of the constraints on claims recovery, if you don't follow the process in your contract with respect to providing notice to the government as soon as you know that that you're doing more work or doing extra work that is not covered by the contract, you may lose your opportunity to file a claim. California has a False Claims Act that you can be prosecuted. It's a felony prosecution for filing what's called a false claim, saying, hey, I did this extra work, but then not having any proof of it. If you stop working on the contract, you think that you're entitled to money, and so you respond by not doing any additional work, you can actually be prosecuted for that as well, and you can and the government can come after you for the cost of reprocurement and doing the work that you were supposed to do. And then the government often has the opportunity to issue change orders to you for extra work, but they also, the administrative department that's awarded you the contract has constraints on that. And so if it results in something more than, say, a 10% recovery over the original value of the contract, they have to go back to their awarding authority and get approval to give larger change orders. Brandon, you want to hit audits?
Sure. Another kind of quick slide. One, most of your, particularly on service contracts, you'll see the right of the government to audit your contract. Well, what does that mean? One, it means that you need to be very careful about keeping and maintaining documents. What we typically recommend, and this is driven by statutes, is that documents be retained for at least 3 years, unless obviously your contract requires for a longer period of time. But also be mindful that any information that you provide could be subject to Public Records Act requests from a competitor. So you just need to be careful, and there are protections that you can call upon. But be aware of audits, and if you get an audit, particularly if there's a problem on the project, sometimes that's a prelude or a smoke in the sky for potential litigation.
James, next slide. So I see that we've got 4 questions already. So I'm going to hit this in just 30 seconds, and then we can move to the questions because we're kind of at the top of the hour. If you're in a government contract and the government decides that they want to terminate it, they've got 2 different options. One is terminating it for cause, and this means that you weren't doing the work that they wanted you to do. And termination for cause is a terrible thing to have happen. You need counsel if that happens. The government can recover damages from you in that circumstance. There's notice and cure rights that are available to you. This can impact you terribly on future contracting opportunities. You usually have to disclose this if you've ever been terminated for cause, in which can go again to the bidder responsibility category. The government can decide you're not responsible if you've been terminated for cause. Termination without cause, this is just the government's decided they either don't have money to continue with the contract, they don't need the services anymore. The contractor usually has the right to recover the cost of the work they've already done, plus a reasonable profit. And if the government wrongfully terminates you, that can constitute breach, and you can recover some additional damages in that circumstance. So with that, I think we can open it up to Q&A. And James, do you want us to read the questions out loud and respond to them? How would you like us to do this?
Yeah, sure. You're welcome to do that. I just wanted to say real quick that if any of you have to leave real quick, we do have a satisfaction survey that you will be redirected to as you leave. It'd be great if you could fill that out. And of course, keep in touch with us. You're going to get our slides and the video from this presentation. You'll be able to review everything, and give me an email at info@norcalptech if you have any questions. So I'm happy to read out the questions if you guys want. Otherwise, you can read them amongst yourselves.
Yeah, I think we can do it. Brandon, you want to take the first one?
Sure. So the first question is, can a bid be protested even if the RFP does indicate it? I think maybe does not indicate it. And the answer is yes. The RFP may not even have a process. And if the RFP doesn't have a process, then perhaps there's the RFP may not reference it, but there could be local statutes or regulations or policies that guide bid protests. And if that doesn't exist, then you can bring the matter up to the relevant decision maker. So let's say a city council that's about to award a decision. In that case, pay attention to the agendas and when the contract's going to come up. And then as kind of the fail-safe, then you're looking in a world of potential litigation. That would be your ultimate remedy, where you could protest it through the courts.
Our next question is, can we talk about the release of proprietary information in a bid proposal pursuant to a records request? And this comes to us all the time. And oftentimes when you submit a proposal, the government will ask you to identify the information in there that is proprietary or a trade secret. There's very little information that actually meets that standard. And so when we request proposals, another bidder's proposal, cost is definitely not proprietary. And the solution that the other contractor provides is not proprietary. There's very little information in a proposal that would ultimately not be released pursuant to a Public Records Act request if the issue gets pushed and it goes to court and the court has to review it. Financial information would be considered proprietary. If you have followed the trade secrets requirements and kept information out of the public domain and only provided it to governments or to other clients with written agreements that it's going to be kept confidential, then that information might be kept out of a Public Records Act request response.
I'd like to add a quick point on this too. Something that we will see on occasion is the over assertion of what is proprietary and what's not. And you'll, particularly in the bid protest situation, you may have a winning bidder that has asserted that significant portions of its bid are proprietary, so much so that it prevents you from being able to determine on the face of the bid whether that bid was actually responsive to the RFP. And when that happens, theoretically, that could be in and of itself a protest ground, right? Because bidders are entitled to at least some semblance of transparency. The public's entitled to some semblance of transparency. Where that line gets drawn is up to litigation, and it can be a very complicated issue, and at least in California, hasn't really been clearly decided yet. But I only note it because it is an important distinction that you can't simply assert that something's proprietary. You need to you need to have a basis for it. Otherwise, you may find yourself hurting yourself in the long run.
This is also a question that isn't limited to the bid protest process. Many of our clients on a routine basis, even though they decide not to protest a particular procurement, will still request copies of the competitors' submissions. Even when they win, they'll request copies of the other competitors' submissions, and they use that for market research, to keep up with what their competitors are doing. And it's a good process to follow. If you folks are in that situation, asking for copies of the other bidders' proposals is always a good way to see where you fit in with the rest of the competition.
So Then I'll just take the next question. The next question, can a debriefing be requested even if it's not indicated in the RFP? The answer is yes. I mean, once a notice of intent to award is given, depending on the RFP, there may or may not be blackout restrictions, but once the award is actually made and there's a contract in place, then there's really nothing precluding the government agency from providing a debriefing. Now, whether or not they're willing to do so is a different process, and whether or not they're required to do so is also kind of a different question. But in principle, don't ask, don't get, as long as you're kind of working within the rules on communications.
Right. Our next question is on responsiveness. Our slide stated that responsiveness will be determined based on the face of the proposals unless the government relies on information outside of the proposal. And can we elaborate on this? James, don't delete this question yet because it's several parts to it. So what information could the government rely on outside of the proposal? So the government's allowed to Google your company and see if there's information out there on your company, and they will do this. They don't always do it, but they will do it. If they've heard of your company before, they've heard people talk about your company, they can pull information down. You're often also required to provide references, and so they will call your references, and your references can give them information on on the work that you've done on other contracts. So that's information that's not in your proposal, but it's information they've gained from the information that you've put in your proposal. And then the last part of this question, do proposals need to meet every single detail as specified by the scope? So we kind of covered that in the responsiveness slide. If the government requires, a certain solution, and they tell you, either quantity or performance requirements, you have to meet that. If the government tells you things like insurance requirements, you have to meet that. If they say you have to provide the services for, X number of hours a week or a day, you have to meet that. There is some fudge room in some circumstances, but the best thing to do is to meet all the requirements. If you're concerned about whether or not you can, it's best to submit a question before the bid is due and see if the government will give you any leeway on that, rather than just put something different in your proposal.
And one way to think about it too is oftentimes when the government is evaluating bids, it'll do kind of an initial review, kind of check the box, is A there, is B there, is C there, and then later go back to kind of talk about the quality of that response. So think about responsiveness a lot of the times as, you're either responsive or you're not. And then the issue with respect to whether or not it's good or bad might be a different question. Obviously, there's even gray areas between that, but that's why it's so important to try to be as responsive as you can.
Brandon, you want to take the next one?
Yeah, so is providing a bid spread and the name of the awarded contractor part of the bid process? So, and I'm assuming a bid spread is kind of, I will define it as, for those who don't know, kind of where all of the bidders rank, essentially, if there are multiple bidders. And the common process is for the government to at least identify who is the awarded contractor. They aren't necessarily mandated to provide the order, although I don't know if I've ever come into a situation where they haven't done that. And the reason why they do that is there are cases that require, again, some level of transparency to educate the public. If in fact you don't get that, then that's the sort of information that you'd want to request either informally or through a Public Records Act request. And then finally, whether or not it's actually required really will depend on, if it's not in the face of the RFP, whether there's a statute or a regulation or a contracting policy that does require the given agency to identify the ranking of bidders.
But our last questions are kind of along the same lines. Are agencies required to provide notification of award? and what happens in the instance the agency does not provide a notification of award. So again, you don't often see this circumstance. Maybe on smaller contracts, you would see this where they put out an IFB maybe for a small, $5,000 contract. But if it does happen, you can check in with the contract awarding officer on a regular basis, see if they've awarded the contract. If you find out they have awarded it and haven't issued a notice, then you can submit your Public Records Act request and ask for the information, who was the bidder, what was the value of the contract, and ask for copies of the other proposals.
Yeah, and pay attention to the schedule in the RFP or the IFB, because oftentimes they'll give you a rough estimate as to when they're going to make their selection decision. You can follow up with the agency to kind of ask the timing question. And then also pay attention to, if you're in local government at least, agendas. And because you may see a meeting agenda for the approval of a contract, and that in and of itself would obviously provide you notice of a selection decision.
Right. All right, I think we've hit all the questions.
All right, excellent. Well, it is come time to thank you guys very much for partnering with us for this event. Thanks for your expertise in putting together the presentation. And thanks again to Olivia, who's been behind the scenes making this happen. And to all of our attendees, thanks. And just one more reminder, you're going to be receiving the slides as well as the video. They're going to be emailed to you and posted to our website and YouTube. And you will also be directed to a satisfaction survey. If you could fill that out, it just takes a couple minutes. You can do it anonymously. It really helps us keep our funder happy and improve our services. So keep in touch with us. You have our contact information. We're here to help. So we hope you'll visit future webinars. And thanks for joining.
Thanks for having us, James. We appreciate this opportunity.
Absolutely. So do we. All right. Have a good afternoon, everyone.